Some are on Zoom. Okay. This is our new policy. And we've adopted a hybrid meeting policy where we meet both in person and virtually. All committee members are required to be in person unless they have special reasons signed off on to be excused. Okay, and we have an agenda tonight. I just want to let you know, if you're not aware, that the agenda has been modified. Item number 1 on our agenda has been postponed. And item number 7, which originally, and I don't know what your agenda that you have has been updated or not. Now the update of the agenda is late this afternoon. Item number 7 originally asked for hours of 11 a.m. to 2 a.m. 7 days a week. And now they're asking 11 to 4 a.m. 7 days a week. Those are the modifications to the agenda. So we have 7 items on the agenda. The first item on the agenda is what previously was item number 2, 122 West 26th Street, Annette Osher of the entity to be formed.
Do you want to remind everybody that we are not approving anything
No, I'll do that. So just for people who aren't familiar with our procedures, this committee hears applications for liquor licenses. What we do is we make a recommendation to the full community board for as to whether we want to recommend that a license be granted or denied. The full board will vote on this at their next meeting, which I believe will be on January 2nd. Neither this committee nor the full board, however, has the power to give a liquor grant or deny a liquor license. All we can do is make a recommendation to the SLA, which makes its own determination. But anyone who's interested in any of these items can make their own submissions directly to the SLA and also be heard at the various public hearings. Most of these applications will have what's called the 500-foot hearing, which is where an administrative law judge has to determine that an additional liquor license would or would not be in a public interest. That's a public hearing. Anyone can show up at it. Anyone can speak at it. And then it is also possible that thereafter this application will actually be heard live by the 3 SLA commissioners. But that's all the process after. The next step would be the full community board vote after tonight's vote.
Right.
And just to remind everyone, as Bert said, this meeting's being videotaped and also live streamed over our YouTube channel.
And I'd like to do quick introductions. I'm Bert Lazar, co-chair.
And
I'm with the LP.
I'm Frank Halsegate, the other co-chair.
Greg Morris.
Christine Birthday.
Tina Nelson. Wendy Gonzalez.
And
on Zoom, members of the committee, introduce yourself.
Carrie Keenan.
Inga Evchenko.
Okay, thank you. So our first item on the agenda, as we said, was 122 West 26th Street. We have some questions.
Well, we want to let that present briefly.
Where is the attorney present?
Can you hear me? This is Martin Miller. I'm the attorney for Annette Osher.
Would you like to do the presentation, man?
All right, thank you. This is an application for an on-premises liquor license. The proposed method of operation is that of a restaurant and a gentleman's club. It's to be operated between 11:30 a.m. to 4 a.m. 7 days a week. It has 2 floors. The premises is located at 122 West 26th Street. The upper floor, the ground floor, the first floor, has a capacity of 255, but there'll be no more than 150 people at most on that floor. There'll be 40 people on the in the lower level. The number of tables on the first floor will be 18. The number of tables In the basement will be 21. There'll be 54 seats on the first floor, 32 seats in the basement. There'll be 2 bars, one on the first floor, one in the basement. There'll be 14 seats in the one on the first floor and 6 stools in the one in the basement. The idea here is to have an adult gentleman's club and a first-class restaurant inside the premises. The owner is somebody who is well steeped in catering events, in owning her own premises that have liquor licenses. She has a son that has been in the management of various adult establishments for the last 8 years. There is an additional general manager who has even more experience in that. Just so everybody understands what we're doing, this will be a premises that will feature adult entertainers, topless, who will perform in various sections of the club. There'll be security of at least 5 people, and it will be supervised by a retired police officer. We are asking for 4 o'clock in the morning. We anticipate no more than possibly 40 or 50 people being in the premises at that hour. But the reason we're asking for 4 a.m. is that the other adult establishments in the city of New York and Manhattan do stay open till 4 a.m. As somebody who's been an attorney either with the authority or on his own for over 48 years, I can tell you I've represented a number of adult establishments. They are not a problem to the area. As a matter of fact, they aid the area in the sense that when this place closes down, we're not going to have some crazed 20-ish crowd coming out, spilling into the street and causing all sorts of problems for the area. The 5 proposed security guards will be outside, and the purpose is twofold. One, to maintain order outside that premises when it closes. They don't anticipate any trouble. There hardly ever is any trouble in an adult establishment. One of the main reasons they want to have the security outside is for the protection of performers. They don't want the performers to mix with any of the people that will frequent the club. We're making a straightforward presentation. We need the hours that we're asking for. The owner is present, I hope. I don't see her on the screen, but she's there to answer whatever questions you may have as it relates to this establishment. And I just also like to say that Community Board number 4 has seen a number of adult establishments, and I venture to say that you have no problems in the sense of anything related to disorder or anything related to what you could have from a nightclub when it lets its patrons out at the end of the night. It doesn't happen in these places. Her staff, I was going to say her staff is well trained, and it'll be a very orderly organization.
Thank you.
Thanks, Martin. As you can imagine, there's been intense community interest in this. Before we get to that, there have been what seem to be serious questions raised as to whether the zoning allows this. Are you prepared to discuss that?
Yes, if you'd like. This premises will be known as a 60/40 club. It will not be a 100% adult establishment. As of today, we have to upgrade the CO. That's true. The owner has engaged an architect to do that. But that's our intent, to have a 60/40 club inside the premises, which means that no more than 40% of the establishment can have the adult entertainment.
Is that something specified by the zoning?
I'm sorry, what?
Is that something specified in the zoning, 60/40?
Yes.
Where does that terminology come from?
It came from the zoning, the adult zoning regulations that were in effect back in 1996. There's been a lot of litigation relating to it, but as of right now, it is still permitted because there are various there is a court stay which allows the clubs. There are clubs, 60/40 clubs in Manhattan. In fact, in all.
Can you give us a provision of the zoning resolution?
Yeah.
Because we're
Today,
looking-
as of right now, no, I cannot. I'm sorry. I wish you, if somebody
And
asked
is
me,
the
I'd give you the
60/40
provision.
referring to time allocated to activities?
I'm
Does the
sorry.
60/40 have to do with time allocated to activities or square footage of the establishment? What is the 60/40?
It relates directly to square footage of the premises.
So how does that work? Would you be dividing this up into separate rooms? I mean, it's one big space.
No, that's true. No, hopefully you have the diagram, the last diagram that we submitted, which shows how it is divided up.
Okay, and so only some of those rooms are gonna have adult entertainment.
Correct.
Okay,
The two will not, in answer to your question, you will not see adult entertainment throughout the entire club. It doesn't work that way.
But where?
Do you have the diagram? I mean, I have no ability to get it up on the screen, but you should have
we
it.
have it, we have it.
I mean, right now, it looks like 40% is adults, and 60% is.
But it has to be the other way, right?
No, it's the other way. Rest assured that the plans that have been sent to the buildings department have a 60% component that's non-adult and a 40% component that is adult.
Can we get a copy of those plans?
I would think so. I don't have them. Like I said, she's engaged an architect. I don't know how far. We realize that unless we have the proper zoning, we can't do what we want to do. What stage the architect is in right now with respect to the plans, I couldn't tell you. I've been in touch with him on the preliminary plans that you see, the diagram that you see, but I don't know where he's at with respect to submitting the plans. And to be quite candid and frank, we are coming here tonight. I understand what we have. I would hope that the moral issue of having a performer perform topless does not become part of this conversation. I mean, you can make it a part of the conversation if you want, but I would hope that Manhattan in 2023, because these clubs exist here.
We're talking about square footage. We're not talking about moral issues.
I'm sorry, what?
Talking about whether you comply with the zoning. The zoning is not, there may have been moral issues in enacting the zoning, but the zoning is now the law.
That's correct. That's
Okay.
absolutely correct.
And what we are asking for is whether you comply with the zoning, because we don't want to spend hours on this application, which we likely will, if we're gonna find out at the end of the day that you don't satisfy the zoning.
And also, if I may, we need to have the plans submitted to the SLA being consistent with what is submitted to the Department of Building. Because, we know what happened to plans. They shift around, right? So we need to have that clear.
I don't disagree with what you're saying. I'm saying I don't know where, in fact, the architect is with respect to the plans that he has submitted to the if in fact he has submitted it.
Okay,
I know I've spoken to him. This is his intent. This is what he's going to do. This is what the owner wants him to do. And I mean, but to a large extent, it hinges on whether you understand the concept and are okay with it.
We hear your intentions. We hear your intentions, but we have tentative drawings in front of us. And we can't make a decision on something that's tentative. You have to see the final drawings.
May I suggest?
I would suggest that when you have that, you come back.
May I suggest this? We will, if you want to stipulate that we have to give you the precise plan showing that it'll be a 60/40 concept, make that a stipulation of what you want to do. There are costs involved.
Mark, excuse me, let me give you some context on this. This place at this location had been the Ainsworth for 15 years, which was an absolute blight on the neighborhood. No one could do anything about it. This community board spent probably hundreds of hours trying to resolve the problem. So it is a location that has huge sensitivity to the neighborhood. In fact, this board recommended denial of an applicant just 4 months ago, I believe,
Yeah.
that did not have an adult component, but we just think this space run as a 4 AM club is just inappropriate for this neighborhood, given what we know what's happened. So adding adult use to that is, you know, a potential big differentiating factor. And this committee would have a radically different debate, and the community would have different concerns if it is or is not a partially adult establishment. So you're asking us to have a hypothetical discussion, which I frankly think is not fair to us or to the community.
If I may, it is not a hypothetical discussion. The Ainsworth, I'm well aware of the problems that you had with the Ainsworth, but that's precisely what I said in the beginning. This will not be some 20-something crowd that will invade this place on a nightly basis. It's a suit and tie men's club. The average age is probably 25, probably closer to 30. That's the point. That by having this adult establishment, a first-class gentleman's club, it will eliminate your problems vis-a-vis something like the Ainsworth. We're not going to have that kind of, there won't be a crowd in front of the place.
Keep in mind, you're switching the topic right now until, from the actual physical condition and the zoning ordinance to who you're assuming will be your customers, okay? So let's still stay with the zoning. I don't want to waste our time or anyone else's time on talking about something hypothetical. Can't make a decision on something hypothetical. I see another committee member with a hand up. Karen?
Yeah, I just want to add to that, like I find I'm a little bit, I feel that the proposed security plan is a little bit iffy as well. It's proposed, it's not a security plan, and I don't see like a soundproofing plan. So for me, when you put the three things together, it's a lot of question marks that you're asking us to go, go like take on faith, and we have, as I'm sure you're aware, a number of letters of concern from the community, like a very large number. So I'm having difficulties with those three major things. Like,
Can I address that?
yeah, of course.
Committee members.
Sorry, the 60-40 rule again. So Martin, just looking at, I know that these plans are preliminary, but looking at the legend and looking at the breakdown of how they're calculating the 60% and the 40% portion, what's not clear to me is whether the 60-40 rule is total square footage, because included in the 60% non-adult space is the kitchen, are the restrooms. So they're not the public space, like the business space. So I don't know if that is how the 60-40 rule works. It feels a little disingenuous if that's how the 60-40 rule works, but I think we would need clarity on that, because from a business, from an operational perspective, the majority is adult space. It's the entirety of the second floor, so it looks like from this preliminary plan, and roughly it's about a third at least of the first floor.
So Martin, we want to give you and your client a true opportunity to be heard while we are all in agreement with the facts. And I guess what you're hearing from us is that there are too many of these facts still in flux for us to meaningfully consider this tonight. So I think we would strongly urge you to postpone and come back in a month or whenever you're ready.
All right, can I do this? First of all, I'd like to address certain things that were said. Again, this is a matter of course. We will come in if necessary, if you are somewhat positive to our concept, we will come in with a plan for soundproofing. We will come in with a plan. I don't understand why this is sort of iffy with respect to the security plan. We were very clear that there'll be one person in the front of the place, outside of the place at all times. There'll be 3 people on the first floor moving around the place. There'll be 2 more down in the basement constantly monitoring what's going on. And the retired police officer will be supervising the entire project. But it's a matter of cost. It's a matter of expense. To do all of these things now and then find that that CB4 is going to say no under any circumstances is a waste of money. And that's why we're coming to you being extremely no one is hiding what we are, what we're going to be. In terms of that, but in terms of the 60/40,
definitional issues, like what Wendy just raised, very important. How do you determine the square footage?
the square footage,
Only to be used by the 60%, not by the 40%? I
The-
mean, we have to have clear definitional issues, clear plans.
may I address this? This was all addressed in 1996. In order for this 60/40 club to be viable, it must be approved by the New York City Department of Buildings. It's very simple. So we can give you a plan which will satisfy the 60/40 concept, but we've got to understand what our chances are with respect to this committee. I mean, if you want me to try and come back next month, I will do that, but I don't know that I'll be able to. I mean, I'll have to have a long discussion with my client about the costs that you're asking her to take on right now. And I'm not looking for an advisory opinion. I'm telling you that in order for us to operate, we have to comply with the law. And that is what our intent is, to comply with the law.
Two more committee people, three more, Tina, Christina, and then Inga.
I have to say what you're asking for, I'm not capable of giving you. Because if you're asking for a tentative vote from me, I'm not able to vote on something when I don't have the underlying information that was asked for tonight. So I'm sorry.
What is that information? The physical plan to the buildings department?
That's what I just raised before. We need physical plans, we need the definition of the 60/40. I'm gonna repeat what Wendy said, because I think that she caught something very important, that the 60% includes bathrooms, which everybody uses, and kitchens, which everybody uses. It's not, is it a public space, right? What are you talking about? Christine?
Yeah, I think I understand where you're coming from. You want to get a sense of, direction so that you don't go around and spend a ton of money. I understand that.
Exactly.
But at the same time, we don't want to spend tons of time. We have probably 30 people lined up to speak on a subject that we don't understand. So I think it's a little bit of a catch-22 here. And at a minimum, you should come back with the resolution of the Department of Building. At a minimum, and it would be better to have the other two things, which is what is the plan, the security plan, and what is the soundproofing plan. But at a minimum, we need to understand whether this is permitted or not. And once, assuming it's permitted, how does it look and how permanent it is? Whether it's defined by, movable chairs, or whether it's defined by built-in banquettes, etc., so that it remains 60/40. So I think we are all trying to avoid a lot of stress, and we understand your situation, but we really can't do anything about it.
And if I could add one thing to that, completely respecting that you and your client need to make smart decisions here, because I do think the 60/40 rule also potentially has implications for revenue as well, because you need to know whether, your client needs to know whether the 60/40 rule can include things like the kitchen and the bathrooms, because if not, then the potential revenue per square foot has just reduced if you have fewer spaces that can be used for adult entertainment as well. So I think, completely understand you want that clarity from us, and I think you understand our limitations. But that's the other reason why this isn't just a small question, it's a pretty significant one.
Okay, Inga?
All right, I hear what you're saying. I will ask that we put it over.
I don't have a committee person, Inga?
Yeah, so I did look it up earlier today, and the 60/40 is the material floor space. So if they want to take 60% and make it a shower, that's 60, and the 40 is the adult entertainment. It's the material floor space. So that's how the zoning law has been interpreted in
That's right.
everything I read today.
That's correct.
So we can say the kitchen is part of the 60. The bathrooms, it's the material floor area is dedicated. So 40% of the material floor area under the New York City Law Department interpretation is 60/40 as material floor space.
Well, Inga, I mean, that's helpful, but the board has actually been in communication with the city for a week and has been unable to get a definitive answer.
Mhm.
So I think it may be more nuanced than, and I've been looking at it for a couple of days too.
Mhm.
I think the basic issue, though, is what everyone said. It is a problematic application with, to me, without the adult entertainment aspect, just like the one was 2 months ago.
Mhm.
And just so you know, we recommended denial of something 2 months ago and
Right.
said if it had to go forward, we could only possibly be comfortable with a 1 a.m. closing.
I saw that. I remember that.
Although every application is different, every applicant is different. If
Mhm.
you look at that letter from September 2021,
Mhm.
you'll see some of the sort of structural concerns, I guess, we have about this space.
Mhm.
But we can't really take an alternate vote that it may be partial adult or it may not be. So I really do think we need to ask you to postpone and come back.
All right, I hear what you're saying. I will make the the command decision unless my client gets on and says no. That
I
we
think she had her hand raised.
She did? Okay.
Oh, she in the
Where?
yes, she may be in the participants section.
Annette here, okay, Annette,
I did. Hi. Can you
Not great.
You're
Can you hear
breaking
me?
up.
Try one more time, Annette.
I'm trying to get on.
There's just some
now.
static.
Can you hear me?
Yes,
But you can hear me. Hi, I'm sorry, my vid's not working. I'm not quite sure why. My
We
name
can
is
hear you.
I.
Annette, do you
Am I
want to
back
call
on?
your attorney and he could put you on speakerphone?
Okay, that sounds good.
Call him and he could put you on speaker.
Do we? Don't we know that at the end of the day, we're going to deny it?
I'm still waiting. I don't have, hold on.
I want to know the facts of what we're denying.
Yeah. Yes.
I got it. Okay.
Annette, can you hear me? Oh, here we go. I'm
I
sorry.
can.
I got it. Okay. Annette, are you on? All
Hi.
right, so I
am
have her
on.
on my speaker. Can you hear her?
Yeah, she needs to mute herself online.
Mute yourself online.
Okay.
Okay, she's on.
Okay, I'm on. Hey, I'm Annette Osher. My intent is to bring corporate men to the business. I have an extensive background in children.
Okay, and I'm sorry to interrupt. Annette, we're trying to deal with the threshold issue of whether you will agree to come back when we have more facts about the permissibility of the adult entertainment aspect. Will you and your lawyer agree to postpone and come back to this committee next month? That's the question.
If we have to, yeah, but
That's what we're
move
asking.
forward with
I
any.
think if we have, my sense of the committee is if we have to vote tonight, it'll be a recommendation of denial.
All right, Annette, what they're asking, I think I've stated our position very clearly. I mean, I think the committee would agree with that. What they're looking for is more clarity with respect to the 60/40 aspect of this club. And we're gonna have to show them some more information. Now, whether it'll entail the plan that goes to the buildings department, or we can maybe get something from the city with respect to the 60/40. That is what they're looking for. They're not looking, you're not in question at the moment. Apparently, the operation is not even going to be discussed at the moment. What is being discussed is whether this premises can comply with the 60/40 provisions that allow for something like this. Is that correct, committee? So
Yeah.
We'd like to be briefed on the legal basis for this whole thing, because I've seen the 60/40 applied to adult bookstores, but applying it to a club is new to me, which again is why we're struggling with how do you apply it to a club that doesn't, you know, that has people moving around and doesn't have merchandise and things like that.
This was answered in 1996. I mean, I can go into a 1-hour explanation as to why the two don't mix. The 60 part remains a 60 part, but I don't think you're going to want to hear this at this moment. So
we want the reference.
We just want the zoning provisions that say you can do this here.
No, also we want the reference to 1997, whatever he
Yeah.
reading.
Yeah.
I'm sorry, the what? I'm sorry.
We want the legal authority that says you can do this here.
No, I can show you the case law, but all right. What we're looking for, I guess, what we have to come back next month and give you a legal explanation.
Send us the stuff in advance and we'll read it to the same
No,
time.
yes, I don't plan on springing it on you that next, the next. You'll get it before you.
Okay, thanks. And you'll agree not to file with the SLA until you come back to us.
Yes, that's correct.
Is
Okay.
there anything else he needs to bring with him for next time so we can hear his?
Well, yeah, there are questions about the security plan. I guess, is there an acoustic plan?
And it's soundproof.
Yeah, but I mean, see, this is going back to
No,
what
he
we
wants-
actually have to show the acoustic. I think if you want the security plan more defined, that can be done. But in terms of having an actual acoustic report, et cetera, that's expensive. I mean, we will have proper, there'll be no outside component to this thing. We will have adequate
So Mark, I think the things we
soundproofing
want-
based on what an engineer will say.
Yes, I think we want the legal authority, whether it's a zoning resolution or case law or whatever, the legal thing that says the 60/40 rule applies here and would allow this to open if you comply with 60/40, even given all the surrounding residences and all that.
All right, I hear you. I
And
understand.
then what you want is the factual information that shows you fall within the 60/40 as defined by the law you sent.
And the
Okay.
floor plan.
And a floor plan.
Definite floor plan.
All right, I hear you.
Okay?
Thank
Okay.
you.
Recommendation.
Okay.
It's just, there is a note in the testimony from the 26th Street Block Association that there had been no direct outreach to them. So just a recommendation potentially.
That's it.
Yeah, you really have to, I mean, the local residents are dead set against this. And they're gonna come back next month and do this, so anything you can do to meet with them in the next month. The block associations, I mean, they're very active in this because of all the Ainsworth history. If you can meet with them and, convince them, that you're a better operator and that this is a better use here, you know, that would obviously help your case a lot.
I hear you. There's been outreach, but okay, I hear you. I get it.
Okay, I'm glad you hear us. Thank you. We'll see you next month.
All right, thank
Okay.
you.
Thank
Thanks.
you. Item number 3 is 450 West.
All right, so just a second, so
Okay.
thank you all for coming out
Thank you.
tonight, but
Yeah.
we didn't want to spend 2 hours on this tonight.
Are we still on?
Yes,
Yes.
okay, but they're not doing anything with the SLA, they've agreed to that. And
Oh.
they will come back.
We're against it.
You know, we just felt we didn't have the underlying, we didn't know what they actually wanted to do there. So it makes it impossible. to
Well, we
address.
do, that's why we're there, they want to talk to us about it.
Okay,
Okay.
thank you. Maybe we'll see you again next month.
See you next month.
Okay, be well. Okay, 450 West 33rd Street. It's 6 to 8 floors, Restaurant Associates. Their hours of operation, 8 AM to 7 PM, Monday through Friday.
And it's actually 3 agenda items.
Yeah, let's,
I mean, we'll have to vote on them separately, but I'll leave it to the applicant
Right.
to decide whether they want to address them separately.
okay, applicant and your attorney for the applicant.
Applicant is on Julia Gabby.
What?
Is your,
Attorney here?
Attorney is on Lindsay.
so
Karina.
Lindsay, you're on mute. I don't know who wants to speak. But Lindsay, you're on mute.
There we are. You can hear me okay?
Yes.
Okay, thank you for that. So I'm here for Restaurant Associates. Julia here with me is going to be overseeing the on-site operations. So I'm going to start with 450 West 33rd Street, floors 6 through 8. And then I'll speak about the 2 other locations afterwards, which are both at 410 10th Avenue. So this location is going to be corporate catering within Amazon's corporate headquarters. Restaurant Associates, as you might be familiar with them, they have a few licenses within Hudson Yards already. They hold approximately 40 licenses in New York State now. Some of their currently licensed locations include Google. They previously handled the Tiffany and Company Blue Box Cafe before it relocated, as well as the Metropolitan Museum of Art. All of the locations that we are attempting to license today are private catering establishments, which are not open to the public. The premises will just be for Amazon employees and their guests. Currently, these locations are operating with food service without alcohol. So once the alcohol license were to be approved, it would have no substantial impact on traffic patterns or the surrounding neighborhood, because there won't be any additional people going to or from the building. We're really just servicing the employees who are already there. The types of corporate events that will be held at the location will be events such as company parties, birthdays, anniversaries, or employee happy hours. And that's why we're only seeking hours of operation for 8 AM to 7 PM Monday through Friday. For the 450 West 33rd Street location, we have no outdoor areas that would be part of the location, and the only type of entertainment would be piped in background music. Please let me know if you have any questions on this particular location.
I know you're experienced here before us, so 7 PM means everything stops. It's not like last call or something. You are.
7 PM, all of the food and beverage service would stop. There may still be employees finishing up work, but that would be when any parties would end.
Okay, just want to make sure you are comfortable with that. The people, we're gonna have to take individual votes,
Yeah,
so,
because they are different.
yeah, so anyone,
Any questions on any of them?
well, we haven't heard about this one.
But the public.
Yeah. Valerie, anyone from the community hear about it?
Sorry, no, there's no one with a raised hand.
Okay, thanks, Nellie.
Okay, do we have a motion on, 450 Westwood?
Motion.
Second.
Second.
All those in favor?
Aye.
Oh, Mike, you're here.
Yes, sir. I am here.
Okay, opposed, anyone? Present not eligible? Abstaining. Okay.
Thank
Okay,
you.
next one.
So the next one, I'll talk about the 16th floor of 410 10th Avenue. This location is also corporate catering for Amazon's corporate offices. Again, the food and beverage service will only be for Amazon employees and their guests. Restaurant Associates is also at this location currently providing food service without alcohol. So that, again, when the alcohol service is added, there will be a very little impact upon the surrounding area. We're looking at the same type of company parties that I just mentioned for the other location. The 16th floor does not have any outdoor areas that would be part of the premises. And again, we're looking at just background music and the same hours of operation.
Wait a minute, the 16th floor said terrace, capacity 124.
Yeah, one of these.
Oh,
has
I have, and correct me, Julie, if I'm wrong. Is the 16th floor with the terrace or
Yeah.
is it the 20th floor? Okay, I apologize. I crossed the two.
That's
So
okay.
the
20th floor does
16th
not.
floor, 20th floor does not. The 16th floor does have an outdoor terrace. There would be no sound piped into the outdoor area. All of the background music would be kept within the inside of the premises.
In the cafeteria.
Okay. Yeah, because Lindsay, I was actually gonna ask you about that. If you go to page 6 of the stipulation form you submitted.
Page 5.
No, well, I'm on 6. You have a question about 5. Our page 6 and 10. The outdoor
Okay,
items, outdoor items other than sidewalk cafe, you have that page?
Yeah.
Yes.
5.
Yeah, okay, so on the question, there'll be no amplified music as per the law, you answered yes. That's about 6 questions down, and then 5 below that, you put in the margin, not applicable background recording music only. So I'm a little confused, is there any music outside or not?
Would
We
you be
don't-
able to, go ahead, Julie.
I can answer this. We do not have speakers outside at the moment. They're really just contained. It's really just like, it's Amazon. So they have like a little Alexa speaker inside the cafeteria. Other than that, I mean, it's really just corporate luncheons and that's really all that's held on site. Maybe a retirement lunch.
But are you playing, is there any kind of music played outside or not?
No, we never play music outside and there are no speakers outside.
Okay, so Lindsay, I think we should cross out that background recording music only, because I think that's confusing.
Sure.
You see what I mean? I mean, that suggests there is background music, but you said above there wouldn't be, so, which is what we're hearing.
I think we meant to indicate just for the inside area, but we can amend that and just change that.
You don't have to do it, we'll cross it out, we can handle it.
Okay.
What about the seated food service?
That, I think, if it's catering, I think that matters less to me. I mean, it's until 7 PM. It's,
Yeah.
you know, it's private events.
Okay.
I think they might want the occasional stand-up cocktail parties.
Do we have a resolution?
Yeah.
Nellie, and I assume this, Nellie, anyone from the community?
No, there's no one.
Okay. And we have a resolution for
Yes.
second. All those in favor?
Aye.
Aye.
Okay, all those opposed? Present not eligible? And abstaining. Thank you. Okay, item number 5. We're going up
All right.
now. From 60 to 20.
So the 20th floor, it basically is the same method of operation that we just discussed with no outdoor terrace. So we're looking for the same hours of operation with only background music. And it's, again, corporate catering only for Amazon employees and their guests.
Okay, any questions? Committee? No, Nellie, from outside, committee?
There's no one.
Okay, we have a resolution?
Motion.
Motion, second. All those in favor?
Aye.
Person not eligible, abstaining. Well, thank you.
Thank you very much. It was nice to see all of your faces again. Have a good night.
Thank you. Have a great night.
Moving on. Item number 6, 321 West 44th Street. Okay, hours of operation 11 to 4 a.m., 7 days a week. Okay. Do we have the applicant here, or a lawyer for the applicant?
Yep, can you hear me all right, Bert?
Yeah, go ahead.
So good evening and thank you. My name's Mike Palutis. I'm joined here this evening by Michael Kelleher. Michael will be one of the owners of PMAX 10. We had intended to have Shane Butler here this evening. Unfortunately, he contracted strep throat and had to leave the restaurant early today, so he's not able to join us. But Shane will be the general manager of this store. This is an application for a full on-premises license. As Bert said, it's at 321 West 44th Street. This location was operated as New York Beer Company from 2011 or 12 until COVID. And towards the tail end of COVID, or the meat of the pandemic, the current owners rebranded as Peachy Keen. And it's been operating for a very short time as Peachy Keen. So this is an asset sale and a transfer. PMAX 10 is seeking the same hours and method of operation as was stipulated to by the current licensee. As Bert indicated, a 4 a.m. closing. And as the current licensee stipulated, PMAX 10 is willing to agree to only have a DJ on Friday and Saturday nights. This establishment will undergo a rebranding, and so it will not operate as Peachy Keen.
Michael, for a second.
We missed your last couple of sentences.
Okay, what did I lose?
We're willing to stipulate to something about weekends or something.
Okay, can you hear me now, Frank?
Yes.
Yeah.
Okay. So the New York Beer Company guys rebranded towards the end of the main part of it, right, through the pandemic. It's operated as Peachy Keen for a short time. This is an asset sale, right? It's a transfer. If it goes forward, what PMAX wants to do is abide by the same hours and method of operation as the current licensee. So they'll stipulate to the 4 a.m. closing and have a DJ only on Friday and Saturday nights, which is part of the current licensee stipulation as well. The plan is for this store to undergo a rebranding. So it's not going to operate if this moves forward as Peachy Keen. And although we don't have a trade name yet, you know this group, I think, fairly well at this point. And this will be a gastropub concept, similar to Dutch Fred's, but larger, obviously, because this is a bigger space and more food focused. This is a larger restaurant operation with seated food service, entree style meals. The applicant also wants to continue to use the same sidewalk cafe that the current licensee uses. That's 8 tables and 16 seats. I want to note that the diagram has some of those tables floating, but Frank, I can tell you the current licensee has those pegged against the wall, and our client will do the same thing. So that they will be flush against the wall, just like they are now. All right.
Michael, first of all, your client has no connection to the prior operators, correct?
No, they do not. It's an arm's length transaction. I happen to also appear many times before you on behalf of Hell's Kitchen Hospitality, but that's just coincidence. Frank, I represent.
Yeah, they're both major operators of the district.
They're both major operators in Midtown. They know one another in the sense that they operate in the same community, but Brian and Tony are not going to have any hand in the business should this transaction take place. Brian and Tony, who you know, will be exiting. A new entity is going to be formed, and that entity is going to acquire the assets of New York Beer and Beverage LLC. And that new entity is going to be owned and operated by the McNamee brothers and Michael Kelleher, who's here tonight. So
Thanks. And did New York Beer have a 4 AM license across the
it
board?
does, yeah, it does, Frank.
What we've been doing with outdoor space is that our understanding is there is no ability for anyone to get a new license, a new sidewalk cafe or roadway license at the moment.
There's not.
Because DCA is out of the picture. The rules, as we know all too well, just before this, the Department of Transportation. So, our understanding is you're gonna have to come back anyway with the ultimate application when the rules are set. So we've asked everyone who has come before us since the court injunction that ended the
One table right outside the front door.
to come back with the outdoor space and remove it from this application. Are you okay with that?
I think so, Frank. I mean, if that's the policy, I don't have a choice. I understand the hurdles with the licensing, the permitting through the city. I appreciate that.
Right. Well, we just don't know, for example, the clear path's gonna be, we don't know if the old cafe will comply with the new rules, whether you might be grandfathered in, for some reason, all of that still seems to be up for grabs in the draft rules.
Okay.
So I think that's the only thing that sort of makes sense for everybody. And quite frankly, I live on 44th Street. I've never actually seen anyone sitting at that sidewalk cafe. In fact, the tables are right out there.
It's been buried under scaffolding, Frank, for I think 6 years, right? I mean, that scaffolding has been there for a very long time.
Okay. Appreciate the stipulation as the DJ only on Friday and Saturdays. Does anyone care about hours? We wanted to cease earlier than 4.
The only thing I'm a little concerned is that across the street, you have built this residential building. So the flavor of the street.
Right, we talked about this in connection with someone else.
Right.
Right. Oh, that was on 43rd Street, but it's the same.
Can I speak to that, Christine, please?
Yes.
So I did reach out to all of the folks on the list, right? The groups, the community groups. I heard back from Kathleen Treat only. She was the only respondent. And she indicated that she knows New York Beer Company and those guys well, and has never had any complaints from that location. And what I can say is that in 2011, when Brian and Tony built the space out, they did significant soundproofing at that time. I have the recommendations that were followed in 2011, and one of the reasons there haven't been complaints is that the store is very, very well soundproofed. Michael, we posted on the lampposts. I know he also dropped the notices in the lobby of that residential building across the street. He tried to get people to talk, but it's difficult. People don't answer the buzzers oftentimes. I know that Michael did drop off notices, so we've done the outreach and tried to make people aware of what we're doing. I know Brian and Tony's operation well, and I know that there haven't been any complaints because I'm their counsel, and I would have certainly heard of it.
Right.
And these guys, the PMAX outfit are good operators. They've been operating in CB5 for a very long time, and they're operating in your district, and they run a tight ship as well. They're hands-on operators. So I can tell you that they'll be there, and they're going to button it up.
Okay.
Good. Okay, anyone from the community, Nellie?
No, there's no one.
Okay, so we have 2 additional steps. The DJ will be limited to Friday and Saturday nights, and this application does not extend to any outdoor space. Okay, Michael?
Yes, that's where we agree to both of those stipulations.
So we have a motion and a second.
Second.
Okay, all those in favor
Aye.
Aye.
and those against, present not eligible, abstaining. Thank you.
Thank you. Happy New Year. See you next year.
Happy New Year, see you at the full board. Okay, moving on, we have 2 more items on the agenda. Item number 7, 626B, 10th Avenue, the St. New York City Lounge.
So, so David, before we get started, we've been getting emails all day from the local block associations about the lack of outreach. And that's even before you changed it from 2 to 4.
What's the block?
So it's between 44 and 45.
Oh, yeah.
44th Street just emailed us that they hadn't heard from you at all, and they're, 100 feet away. And we also heard from 45th Street Block Association. And so basically, we're hearing that, they haven't heard anything about your operation, and with the 2 a.m. or particularly a 4 a.m. application, I think it's really in your interest to postpone and come back. I will tell you that the prior applicant came in asking for 4 a.m. and there was a lot of opposition, so they ultimately agreed to 2 a.m. So, I think particularly if you want 4 a.m., it's really in your interest to try to get the community on your side. I'll let you, before we get into it, you can respond to that if you like, but these are very active block associations, so I do think we'd be reluctant to recommend approval without getting some views from them.
David, you want to respond?
Yeah, 2 things. I know that my client's GM is on the call. Her name is Marley. So she'll be able to tell you about the outreach. As far as the hours, my clients do have some flexibility. It's just they want it.
Yeah, well, why don't we talk about outreach first?
Okay, that's fine. So,
Molly, would you like to go?
Hi, how are you? I'm happy to meet you all and happy to be here. So I've came on as GM a little bit later. We did reach out to everyone on the list. I reached out personally to each person. I did connect with someone and invited everyone on the list to come to the space, check it out for a walkthrough, and also would love for them to come and join us for a small plate once we are opened. But there absolutely has been community outreach.
Well, the 49th to 54th Street Block Association wrote to West 44th Street, which is the nearest block association. And they just wrote to us at 7:10. This is the first we had heard of it, no outreach at all, and they're on the agenda for tonight. They said they got an email from you at 1:30 this afternoon, totally unacceptable and a bad way to start relations with the community. Other people have said they got an email sort of inviting them to come in for, visit, have drinks and try the food, but I think did not understand that it was sort of an official, usually the way this works is you appear before the block association. You go to one of their meetings and present to them as a whole. And I think they did not understand because this was sort of presented in a different way. I think some of them who got that email didn't realize that was your official outreach to them. In other words, I think they interpreted it as an invitation as to stop by and look at the place, but it wasn't, ordinarily those block associations would say, can you come and address us at our next meeting, which is what they are asking for now.
To meet with them directly.
Yeah.
I also don't see in the photographs any posting of the meeting, giving notice of this meeting tonight, which is probably a good idea.
well, I'm pretty sure I submitted the photos of the notice posting in my original package to you. I know I haven't.
In any event, the bigger issue, well, this is a big issue, but we also gave notice in our own agenda to everybody that it was a 2 a.m. license. And this afternoon it became a 4A license, so
Big difference.
that's a big difference to the community too. So I think the far neater way to proceed would be for you to postpone, agree not to file with the SLA, meet with the block associations. We can tell you which, or at least offer to, and I think they'll all want to, and then come back next month.
No.
I do want to acknowledge that there was initial outreach from the partners of the lounge on the 17th. And my outreach today was just, or most recently was just kind of introducing myself as general manager and just letting them know my background, a little bit more about the space, and, you know, just a community warm, friendly outreach. So it wasn't initial communication, it was just more of a follow-up communication.
Well, I'm honestly not, I mean, we never find it that productive to debate past, you know, what happened in the past, but it appears that a lot of these block associations thought they first heard from you about this application by your email today. So I can't say what happened, but the fact that we have 3 separate block associations saying they didn't know about this before this afternoon sort of says something. And for example, 4954 actually submitted, you know, their email positions on 2 other people on our agenda tonight. But, you know, say they had not heard from you before this afternoon.
Christine.
Yeah, I also would like to say that the plan for the backyard is really very sketchy. And we don't have any pictures of what's happening around the backyard. I mean,
I've seen it many times.
Right.
And in other times we've asked for, I can tell you this, you should look online for the stipulations that the prior applicant agreed to for the backyard. It was basically reducing hours to 9 p.m. weeknights and 10 p.m. Friday, reducing capacity for 4 tables and 12 seats, and agreeing that they wouldn't be combined. But again, it's all the more reason to talk to people, particularly the people that are above you and in the neighboring buildings. You know, we want to get people as comfortable with you as an applicant before you go in there, before you're suddenly there, and you know, they feel they haven't been consulted.
And also this operation has been problematic in the past, in the far past.
No, this isn't fairy tales. I mean, this isn't Ted's place.
No, I'm talking about that.
What?
The noise in the backyard.
Are you sure it's, you know, talking about?
Yeah.
Okay.
Long time ago.
When it was 44 and a half for a long time, right?
No.
Before that?
Yeah.
Okay. All right.
So anyway, I think some people are going to be very, I mean, the people who live right above the backyard are very sensitive and very focused. That's what I want to say.
Okay. All right.
So they all.
Well, I think that's why we ended up
on the top of it. And then now it's 4 o'clock. It's a totally different animal.
Yeah. Well, as I said, the last applicant agreed to cut down from 4 to 2.
Yeah.
But again, I think what we want is for the community to talk to them about what's important to you and what's important to the residents.
So that we're really looking for direct communication, sitting down face to face.
So, I mean, would you be ready to table? And come back next month?
Well, I'm very happy to amend hours to 2 a.m. And happy to meet with the city direct, you know, each individual directly.
Well, but see, we don't know their position, which we try to be, you know, informed by what the people closest to these establishments think. So it's very important for us to hear that you talk to them and that they then tell us what their views are. And sometimes, you know, they will ask for things we haven't thought of because they are physically closer to where you're operating. So I think it would really smooth the way, you know, if you agree to come back next month after you talked with them all.
Block association. Yeah.
And look at the steps of the last
applicant.
Okay.
No
What
problem.
is, just, what is your next scheduled date?
It's
January 9.
1/9?
Yeah.
Okay,
January 9th.
okay. I think that's gonna be fine, and then we'll go through the outreach process more thoroughly.
Okay. Right, and because it's the holidays, I would reach out to them right away, because I'm not sure when in the month they have their meetings. So if you don't know what the most relevant ones are, you can contact Nellie in the community board office. But it's basically the West 44th Street Block Association and 45th Street Block Association. And then I think Steve Bolita is involved, so what do they know, the
49 to
54.
And then there's the 46 block association, which is kind of.
Right,
iffy.
but who's Alfie Peters with? The 47.
No, 47.
Yeah, you should tell them too. So it's 44, it's 45, 47, and 49 to 54.
Those are the four major block associations.
Right. And I'm not saying they'll all want to meet with you, but we know 44th and 47, 49, 54 does.
Okay. Yeah, I think that's fine.
And if you need contact information, please reach out to Nellie in the board office. And again, you're agreeing, you won't go forward with the SLA until you come before us next month, correct?
Correct.
Thank you. Thank you so
Okay.
much.
Thank you.
Okay. Item number 8, 772-930, Monarch Free Corporation. Hours of operation 12 p.m., 12 a.m. Monday to Thursday, 12 p.m. to 1 a.m. Friday, 11 a.m. to 1 a.m. Am I getting this confused? Monday.
Going by their form, it is Sunday to Thursday, well, Sunday 11 a.m. to 12 a.m. Monday to Thursday, noon to midnight, and then Friday and Saturday, Friday midnight to 1, Saturday 11 a.m. to 1. Basically, they want to open an hour earlier on Saturday and Sunday, open at 11, not noon, and stay open an hour later on Friday and Saturday, 1 a.m. instead of midnight.
Okay. Ready? You ready? Unmute. And we're ready.
They're just chatting.
We're ready.
Are
Are
you guys ready?
We're ready to hear you. Unmute.
This is hilarious.
Argelio Rodriguez, can you unmute yourself
Argelio.
and present your application,
go.
please?
Okay,
Sorry if
unmute.
I got your
Ready.
name wrong. I apologize.
Excellent. You actually nailed it. Thank you so much. So I'll introduce myself. I'm Argelio Rodriguez. I'm the attorney handling the liquor license, and I'm here with the 3 partners of Monarch 3 Corp, located at 772 9th Avenue. I'm here with Marcos Vidar. I'm here with Evelina Clapoca. Close enough. And Mario Zarate. Mario, you can come in to the screen. And so to give an overview of our application, we initially provided the 30-day notice in mid-October, and we were set to be on the agenda in November for the BLP committee. And we received a request from a block association from HK 49-54, and they were requesting that we meet with them prior to meeting with you. Out of respect to them and out of respect to the community, of course, we agreed. And so we asked that this be adjourned till today so that we can meet with them. And we met with them at their monthly meeting at the end of November, if I recall, around November 28, 29, sometime around there. And we had a great conversation. First and foremost, I have to explain that, prior to those conversations and also during them, a few changes were made to our application. We removed the use of the backyard. We also removed the element of live music. And we did agree to some points with the block association. And it's fine if we need to stipulate to them. We agreed, we confirmed our hours of operation. If you need me to summarize those hours of operation, I can, although they emailed them and they're on our application. Should I summarize them?
No, they're the ones we talked about, right? Basically closing at 12 a.m., closing at midnight on weeknights and 1 a.m. Friday, Saturday, right?
Yeah, that's correct. And,
Okay,
and then there was another stipulation regarding the I guess the French doors, the front doors, and involving the use of amplified music. And the idea was that they would be closed whenever there was amplified music. And we agreed to that. That's fine. From our understanding, that's quite customary with them and with this committee as well. In terms of other points of music, it's recorded music. We will have a DJ during brunch only. So during the day on weekends, during brunch hours, 18 tables, 42 seats, and 8 seats at the bar. And we're basically here to see if there's any feedback or anything further that needed to be discussed.
Okay. Well, first of all, I want to thank you for postponing last month to meet with the Block Association. As you might have just heard, that's really important to us, and I think you demonstrate why it's helpful, because you worked some things out with the Block Association and saved us all a lot of time here, so we appreciate that. Those were basically all the issues I saw.
You want to fix the front page on the live music?
Yes, I did that. So, yeah, so we're gonna change page 2 to say there's no live music.
And when you say brunch, you said brunch is the DJ. Do you have specific hours? That's Saturday, Sunday brunch?
Saturday, Sunday.
Saturday, Sunday brunch. You guys
11
have
to
a
3.
11 to 3. 11 to 3 p.m.
Okay, thank you.
And in terms of the amendment of the page 2, I actually did send that in the more recent submission for this meeting. And I also sent an amended 30-day notice updating removal of the live music and removal of the backyard space.
Okay.
That will ultimately be sent to the SLA.
Right. So just to be clear, we'll just add additional stipulations that makes that clear. But there'll be no use of the rear yard, there'll be no live music, and any DJ will be only during brunch from 11 a.m. to 3 p.m. only on Saturdays and Sundays.
And the doors closed when there's amplified music.
Yeah.
That's correct. I did want to make that we spoke with the Block Association, and we would like to return in the future after demonstrating that it is a great operation to request some of those items, probably in a piecemeal way. So we would like to return in the future and have that option available. And we spoke with the Block Association. We will speak with them first, and then we would provide notice when that day comes.
No, and we appreciate that. And if you have good relations with the community, the backyard has been problematic, which is why with prior operators, which is why the Block Association is concerned about it. But yes, if you do this the right way and establish good relations with the community, I agree. That's definitely the way to proceed. So yes, we're always open to amendments to your method of operation. After you've proven what kind of operator you are.
I see Christine and Inga have your hand up.
Yeah, I just, on the application, it's probably Christine's question too, is the outdoor vestibule. You have TBD, which is to be discussed. If you decide to put one there, it can only extend from the building 18 inches out. So it's basically tiny.
Inga, sorry, that's a storm enclosure. They said they're not going to use one. A vestibule is something within your business.
Within the establishment.
Okay, I thought it was the storm enclosure. Okay.
Outside, like a little
Good.
lobby.
Yeah, we understand. Anything outdoors, we need to come back. We're well aware.
No, you can have it. It just has to be 18 inches. It cannot be sticking out more than 18 inches.
If you do a vestibule inside, you can make it as big as you want.
Okay.
That you can do.
Any other committee members, comments?
One note, looking at the email from the HK 4954 Block Alliance, they, in their description of the hours, they have Friday and Saturday from noon to 1 a.m. But the application is actually on Saturdays, it's for 11 to 1 a.m. I think it's minor, and I'm very comfortable with the 11. but I just wanted to flag.
Yeah, thank you for that. Thank you for that correction.
Yeah, and we're staying with what's in your stick form, the 11 a.m. for,
Right.
Saturday and Sunday. The starting time, yeah. I don't think that was.
Cornelia, is anybody from the community?
I'm sorry?
Yes.
Yes, we have Katie Savage.
Okay.
Hi, this is Katie Savage. I am co-chair of the 4954 Block Association with Steve Belita. We're very happy that our Helio and the operators came to our meeting and discussed, all these things with us. We think this will be a great addition to the community. Regarding Steve's misrepresentation of the hours, I think that was just a typo on his part. But overall, we're very happy with the conversation we had and look forward to this business. Thanks.
Okay, and thank you for meeting with them because you did a lot of work we would otherwise have done to work out these things.
Yeah, I only wish that the previous applicant were still on the call to hear how they should have proceeded with their application.
I think they are, and I will say this is the best application I've ever seen. So thank you.
Appreciate it very much.
Thank you much and the applicant. We really, it's a very encouraging sign that you're working together so well this early. So thanks to everybody.
Okay.
Okay.
Do I hear a motion?
Thank you.
Thank you.
All those in favor?
Aye.
Aye.
Okay, those opposed, person not eligible, abstaining. I think it passes. Thank you, guys. Good luck.
Good luck.
Thank you very much. I appreciate it, guys.
Happy holiday.
Okay.
Happy holidays to everyone.
Yeah.
Happy holidays.
Thanks everyone on the committee for joining us live.
And
virtually.
I just want to point this out,
The last times.
only 10 seats.
Right.
Okay, but everyone remember this for the 3 people we asked to come back.
Come back, yeah.
I'll come back.
We will have 200.
Exactly, so.
I told you guys we'd be done on time.
The January 9th.
Storm closure, you remember Stack Street?
Yeah, right.
Right, so we tell them no, and they say, oh, we did something really wrong, etc. So now, they still have the same enormous things.
Yeah.
We just cut it from the side. They don't get it, that it's the deck.
Okay.
Oh,
All right, thanks everybody.
Thanks, everyone.
happy holidays.
Well,
Happy New Year.